Security for keeping peace and good behavior. So, prevention is better than cure is a proverb which is a common parlance and well known. So, Sir William Blackstone believed that preventive justice is preferable in all aspects to punishing justice. Rather than merely being a popular quote, this proverb is deeply embedded in various legal systems as well. Indian criminal law is not completely unwary of the jurisprudential norm of preventive justice. Substantive law states that crime is to be prevented and the procedural law provides a mechanism for the same. So, security for keeping peace and good behavior is very important concept when we talk about criminal justice system. Now, security for keeping peace on conviction. So, for example, if a person is convicted of an offence, so how he will maintain peace and good behavior. So, section 125 of BNSS enables the court to order individuals convicted of specific offences or abetting such offences to execute a bond for maintaining peace. Please underline the word executing a bond to maintain peace. The court which may be a session court or judicial magistrate of first class can require this bond with or without sureties for a period not exceeding 3 years. So, for 3 years you can ask that person to execute a bond that he will maintain a good behavior in the society. So, this action is taken if the court deems necessary to ensure that the individual's peacekeeping behavior. Importantly, if the conviction is later set aside on appeal or otherwise, the bond becomes void. Okay. Hello?
Hello, ma'am.
Yeah, any doubt? Hello? Hello?
Can you hear me, ma'am?
Yeah, hello, any doubt?
No, ma'am, no.
Okay, fine. Yeah, next is section 127, security measures against dismention of seditious matter. Okay, so an executive magistrate can take action when they receive information within their local jurisdiction about individuals disseminating seditious or obscene materials. So this section applies to the individuals who disseminate or attempt to disseminate materials that are punishable under section 153B or section 295 of IPC. So disseminate matter concerning to a judge that amounts to criminal intimidation or defamation under Indian Penal Code. Now, the magistrate may require these individuals to show cause as to why they should not be ordered to execute a bond for good behavior, not exceeding 1 year, if the magistrate deems it necessary to prevent the repetition of those offences. Okay, so in this case, the magistrate will call them to show cause why they should not be ordered to execute bond if they are acting in a manner. Now, section 128, ensuring good behavior from suspected individuals. So, 128 authorizes an executive magistrate, please underline the word executive magistrate, to demand security for good behavior from any person suspected of concealing their presence with an intent to commit cognizable offence. Please underline the word cognizable offence. The magistrate may require that the individuals to show cause why they should not be ordered to execute a bond for a period not exceeding a year as determined by the magistrate. Next is security for good behavior from habitual offenders, like who are habitually committing some offences. So, section 129, an executive magistrate has the authority to demand security for good behavior not exceeding 3 years. Please underline the word 3 years from the individual who fall in the various categories. First is robbers, thieves, forgers or housebreakers, receiver of stolen property with a knowledge of its theft, habitual offenders aiding in concealing or disposing of stolen property, those habitually involved in the offence like kidnapping, abduction, extortion, cheating, mischief or certain offences under IPC, individuals habitually involved in the offence that breach the peace provided they are considered desperate and dangerous. So this section primarily objective is prevention, not the punishment of the offense. It is used to secure future good behavior. Please underline. It is used to secure future good behavior and cannot be used to punish for past offenses. Now what is the procedure for taking security? So the procedure for implementing this provision involves several stages. First is order of security to be writing. The magistrate may issue a written order specifying the bond amount, the need of the sureties, and explain the order to the concerned person. Now procedure when the person is not present in the court. So if the person is absent, the court may issue a summon or warrant for his appearance. Immediately arrest may occur if necessary to prevent the breach of peace. Such summon or warrant may be accompanied with a magistrate's order. So section 134 empowers the magistrate to dispense the personal attendance if sufficient cause exists. Okay, first what will do the magistrate will order that you have to maintain you have to maintain peace and good behavior, and you have to give a bond for that also and sureties also. Next procedure is that if that accused person is not present in the court that time, then summon along with the notice of the magistrate will be sent to that person. Then next is inquiry as to the truth of information, whether the information that the magistrate received was true or not. So upon the person's appearance or that of their pleader, the magistrate conducts an inquiry into the truth of the information that led to this action. The inquiry must be completed within 6 months. Please underline. Unless the magistrate directs otherwise. The magistrate can also detain the person in custody if it is necessary to prevent breach of peace. So steps after completion of inquiry. So if the inquiry proves the executing of bond is necessary for maintaining peace and good behavior, the magistrate may issue an order under section 136. The person is directed to execute a bond with or without sureties. However, surety is mandatory if the person is a minor. So if the inquiry finds no need of the bond, then the person will be discharged. So there are two things. If after an inquiry the magistrate finds that no it is necessary, then it will ask to execute bond, otherwise it will ask release that person. Now procedure if the person defaults in providing security. Any doubt? Hello? Yeah. So tell.
No, continue.
Yeah. So if an individual ordered to provide security under subsection 125 and 126 fails to do so, they may be committed to the prison. If they are already in prison, then they will be detained for further period of time. If they fail to provide the securities by specified date, if they breach the bond that they have already previously executed, means for example if they have given a bond that we will not commit this offense against, and they have committed the offense, in that case they will breach the bond that they have previously executed. Now imprisonment continues until the individual provides a required security or until a specified time period expires. If releasing the person does not pose a hazard to the society, the district magistrate may discharge such individual. So this provision serves a vital purpose in maintaining public order, ensuring good behavior and preventing potential disturbance by requiring individuals to provide securities and adhere to the law. Now we will look into the case laws in Naveen versus State of UP. So herein it was held that the words habit and habitual have been defined. The word habit has a close correlation with the character of the person when it comes to invoking provisions relating to keeping peace and good behavior. It was held that habit and habitually have been used in the sense of depravity of character as evidenced by the frequent repetition or commission of an offense as mentioned under this section. Next is what is the
meaning of frequent repetition?
1 minute. Yeah, now you speak.
Frequent repetition.
Frequent repetition means you are committing the offense again and again. Frequently you are committing the same offense. Okay. Now Abdui Gafur versus Emperor. So in this case it was held that the word conceal presence in section 109 as wide enough to cover not only the concealment of bodily presence in the house or group etc., but also the concealment of appearance by wearing mask or covering the face or disusing by wearing a uniform etc. So all this will also be considered. Now Nikaram versus State. So herein it was observed that the information received by the magistrate under section 108 should not be vague and must be clearly established that the person whom the information is given is by habit a robber, house wrecker etc. The police report by reproducing the word of this section and merely considering the bad name of that person does not really give the information about meaning under this section.